Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law, and, well, hey, anything else we want to talk about. And today is going to fall squarely under the estate planning and elder law category, as our topic for today is going to be when to estate plan. But before we get into the topic of today's podcast, just a quick reminder, please do not take what you receive from this show or any other radio show for that matter to constitute legal advice. If you would like to get legal advice pertaining to a specific situation, please contact an attorney licensed in the state that you are living in to receive legal advice specific to your case and to establish an attorney-client relationship. This is meant for information, educational, and entertainment purposes only. We're going to have a little bit of fun on the podcast today talking about when to estate plan. And the short answer is today or now. But the much longer answer is anyone who is over the age of 18 is deemed to have capacity in the state of Pennsylvania, and they are deemed to be an adult. Therefore, they are to act on their own and make their own decisions for themselves. So what we find a lot is that individuals who are going off to college are often the ones getting powers of attorney in place, because when they're off to school, mom and dad can't make decisions. They can't call the school and ask questions about grades or do any kind of decision making for or on behalf of the adult individual. Why? Because they're deemed to be an adult and they're deemed to make their own decisions for themselves. So what I tell everybody in our workshops and our podcasts is everybody over the age of 18 needs to have a financial power of attorney in place. Now, yes, there is a healthcare statute in the state of Pennsylvania, and yes, there is an intestate succession statute, which means if you do not have a will, the state has one for you. Therefore, technically speaking, your healthcare decisions and your last will and testament is made for you by the government. Now, I will tell you, it is not always what you want, right? So, for example, if you're married and have kids to another relationship, don't worry. Your kids and your new spouse will hold hands in the hospital and sing Kumbaya. Well, maybe not. And if you pass and you're married and you have children to the relationship, to the gentleman or female that you are married to, then it goes the first $30,000 to the spouse, and then you split the remainder with the spouse and the kids 50-50. So I actually had a case where an individual who was a first marriage situation, they had 3 children, and the husband passed away suddenly in the middle of the night and did not have a will. Now, why did he not have a will, do you think? Well, because he didn't think he needed one, right? He was married. He believed everything would go to the spouse. They had 3 kids together. And, of course, when he passes, even the kids and the spouse think everything's going to her. And they came in together, and they were shocked to hear that she got the first $30,000 and split everything 50-50 with the kids. Now, we got lucky. The kids were able and willing to gift the money back to mom, right? And why were they able to do that? Well, because they weren't in the middle of a divorce, they weren't in a car accident, they didn't have a stroke, and they weren't in a nursing home. So they were able to go ahead and transfer those assets. And because of the tax laws that are currently in effect, that a person or individual in the year 2023 can gift $12.92 million, and it will go up in January of 24 to a higher number. And if you're married, it's 12.92 plus 12.92. You can gift from a tax perspective with no issues. But remember, just because you can do something from a tax perspective does not mean that you should do it from a long-term care perspective, or if you need to receive care in the future. So you got to be very careful gifting money away because of that issue. So we just really want to watch that. Now, in this specific case, they were able to do it from a tax perspective with no tax consequence, and the money was given back to mom. But had any one of them been in a divorce, in a nursing home, in a car accident, they would not have been able to do it. So, as I always say, luck is not a plan. You do not want to count on luck. And in that situation, we were counting on luck. It turned out that we were lucky, and therefore they were able to gift the money back to mom. And why did dad not have an estate plan? Because he thought everything would go to the wife. He didn't think that it was necessary. And he also didn't even have a power of attorney in place. Why? Because he was only 68 years old. Who would need a power of attorney at 68 years old? Well, I can tell you, I have a lot of clients who are younger than what you would expect. Some, 18, some in their early 20s, some in their early 30s, who do have a situation arise, whether it be a car accident, a stroke, something that renders them incapacitated or not able to make decisions for themselves, certainly at a much younger age than what we would expect, now have a major issue because they weren't planned for or they did not plan ahead of time. So the question of when to estate plan, I think that the most serious answer that I can give is at 18, when you're allowed to. Now, I fully understand that people at 18 generally don't have a lot of money. They also generally don't have a lot of assets. So, thinking that through and processing to be able to want to do something or think that you need something, I fully understand. It's a difficult concept to get. I think the reason that we see a lot of college students getting powers of attorney is purely so that mom and dad are able to make decisions for the child in case the child can't. And I'm sure that most of the time that is being pushed or prodded along by the parent so that they don't get in a situation where they're trying to deal with the school or other healthcare professionals at the time that the son or daughter would need estate planning. And if left to their own devices, I imagine most 18-year-olds probably wouldn't take the step to do that. But regardless, 18 is the age to do it. All right, now let's go a little deeper. We know that the financial POA should be at 18, and I would argue that the medical POA you should get at 18 as well, so that you're not dealing on a healthcare statute that may or may not be who you want to make decisions for yourself. And if you don't do it when you're at 18 or as close to 18 as possible, I think at the next juncture in life when you have a few extra dollars and could get them done, the recommendation would be absolutely get it done. There have been situations where I've been talking to individuals who own everything jointly owned, who don't have much in the way of assets, in the way of money. And, honestly, I think a will is probably certainly less important than the financial power of attorney. I think that is the most important. Why? Because the only way to have something done in order to have somebody appointed to be able to make decisions on your behalf, if you do not have a financial power of attorney, is through a guardianship. And that is a court process. There has to be a formal petition. They have to serve the alleged incapacitated individual. And it is an emotional process in the hospital. In the courtroom with a doctor from the hospital actually testifying as to the person's ability to make decisions on their own. And eventually a judge will adjudicate the individual as incapacitated or that they do have capacity and that they are not incapacitated. But either way, you are taking away a person's rights to make decisions for themselves. So it is certainly a very emotional process, expensive. Anytime you have two attorneys, you have one for the alleged incapacitated individual, one for the person bringing the petition, and also a doctor testifying. Even if it's over the phone, you still have a doctor testifying, and that is county by county as to whether they can do it over the phone or they have to be in person. But either way, certainly there's expense to all of that. So we want to avoid that if we possibly can. And a financial power, a medical power would eliminate it. In regards to the last will and testament, as I said, I have had people that didn't have much. And I just said, you know what, I don't know that right now you need it. It's really not going to govern anything. Remember, a will only governs what is in your name alone at the time of your death. So if you own everything jointly, for now, it won't go through probate. And the reason I say for now is because, remember, if I own an asset joint with my wife and I die, it transfers automatically to her. But now, how does she own it? Yeah, she owns it in her name alone, which means if she passes away, now we have to have used the will. But for people who don't have much and they don't have any money, ultimately they're willing to run that risk as far as, okay, well, maybe it won't go exactly where I want it, but at least it's going to go to my family. I will say, at least in the state of Pennsylvania, you don't have to worry about the government taking the money. It drives me absolutely crazy when I hear professionals scaring people into you don't want it to go to the government. It's only going to go to the government if there are literally no relatives alive. Under the intestate succession statute, it does look to the closest living relative, and therefore it will go to someone in the family. That is really my biggest concern. That is really my biggest thought process as far as, hey, it's going to family, so it's better than nothing. And if I have nothing, then at least there's better than nothing. So I think the financial POA is the most important. And then you get the medical POA and as well as the last will and testament. As far as when to estate plan, when it relates to maybe more complicated estate planning, I think that the question that I get all the time there is when to do a trust. So as we've talked about on the podcast, trusts are legal contract between three parties: the grantor, the person who creates it; the trustee, the person who controls it; and the beneficiary, the person who receives it. It is the legal contract that sets forth the relationship between those three individuals. And yes, you can be a grantor, you can be a trustee, and potentially have some beneficiary rights, ability to use things. It all depends on what type of trust we are discussing. So generally speaking, there are two major types of trusts. There are testamentary trusts, trusts created under a will, and also living trusts, trusts that are created while you're living. Of the main living trusts we deal with are revocable and irrevocable. And when we start talking about irrevocable, there are different types of irrevocable trusts. There are tax trusts for people with more than 12.92 and 12.92 million. There are trusts that provide asset protection, and the way that we do it is by the grantor giving up something irrevocably, like the right to give it back to themselves. That would be an irrevocable right as to one certain item, even though they can change any of the other terms of the document. So it's kind of a little bit of a hybrid. I will say, as far as testamentary trusts go, if you've read our book, A Fork in the Road, Modern Estate Planning Takes the Other Fork, you will know that in the last year, we have had numerous companies, I think we're over 10 now, tell us that they will not allow a beneficiary designation on an account be a trust under a will. Now, it makes absolutely no sense to me. They've not been able to give me a good reason that I can buy. But ultimately, we're at the point now where we are advising people not to set up a testamentary trust because there is a chance that the financial institutions will not allow you to change the beneficiary to be the trust under the will. One company in particular told me that it's because it is wrought with fraud, and that because it's not set up until death, that it would be too easy to commit fraud. I respectfully disagree. And the reason that I respectfully disagree is because they still have people name an estate as a beneficiary. Well, when is an estate created? Not until death. So if your argument is that a testamentary trust is wrought with fraud because it's not created until the moment of death, well, then tell me why an estate being named is not also wrought with fraud. And I think the answer is they just didn't want to do the testamentary trust anymore. They came up with a reason, and they're going with it. So what I've learned is I've spent a lot of hours arguing, and at the end of the day, these financial institutions are really kind of allowed to do what they want and make up their rules for themselves. And if the client wants to go somewhere else, they can. But most people who have a relationship don't want to do that. So we pretty much have taken the decision or made the decision internally that we are not going to really create testamentary trusts anymore, which are trusts under will. For those of you that worked with our office years ago, we did a lot of these because we were able to get asset protection after death. So a lot of years where we did a lot of these, and within the last year or so, we started doing a lot more revocable trusts to take the place of the testamentary trust and still be able to do asset protection after death planning in the revocable trust. And to the extent that we want asset protection during life, we can do that in the trust that is we call an asset protection trust, which is really a pure grantor trust. It is still in the grantor Social Security number for income and estate tax purposes, but the grantor is giving up the right to give the principal directly back to himself or herself. And by doing that, they are able to get asset protection from the long-term care situation. And we always have to remember that there is a 5-year look back. So as it relates to when to estate plan, my joke in workshops all the time is, when is the best time to plan? 5 years and 1 day before you need a long-term care situation. And everybody laughs and everybody chuckles. And I say, all right, well, if you don't know when that is, when would the next best time to plan is? And everybody says today. And I say, absolutely. Now, does a 20-year-old, a 25-year-old need to concern themselves with long-term care? Well, maybe not. And that can be because statistically, they probably won't need care in the next 5 years. And also probably because they don't have enough money to really worry about it. But where that becomes really iffy to me is, in order to be able to do planning in crisis, which is a completely different type of planning, the way that I explain pre-planning versus estate planning is I make a V with my hands and I show that the V goes away from each other so that the hands go away from each other in a V motion. That means that if you do pre-planning and you have created a trust, you've created all these documents that you need, and 6 months later you end up needing a long-term care situation, we have to come back to the beginning and then go down the other V, which is crisis planning. And in Pennsylvania, we are still allowed to do crisis planning, but we need a power of attorney that authorizes the ability to do the asset protection or asset preservation in the power of attorney. So if you have a young individual who doesn't have a power of attorney in place and they end up losing capacity, you have to go to a guardianship hearing. And not all judges, especially in the state of Pennsylvania, are willing to allow asset protection planning to be done through a guardianship. We have definitely had some success as it relates to spouses, but generally speaking, when you're dealing with a single individual, widow or widowed, generally the courts don't like doing asset protection or asset preservation in a single case to protect children. They seem to be a little more likely to do it when it relates to protecting assets for a spouse living at home, to ensure that the spouse has enough to live for the rest of his life or her life. But relying on that is probably not a great idea, because remember, just because you're married today doesn't mean that your spouse won't pass away, won't become incapacitated, and now you're scrambling, trying to figure out, what the heck am I going to do? Are there still rights and abilities to be able to do the planning in crisis through a judge with a guardianship hearing? So you want that power of attorney in place to avoid the guardianship hearing as early as possible. And timing 5 years is not something that you can do, right? I mean, people are in car accidents, people have strokes, people have unexpected things come up every single day. So trying to time something or rely on something really comes down to relying on luck. And as we have said in almost every episode of these podcasts, luck is not a plan, right? So we don't want to count on luck as our plan. So from a trust standpoint, you generally need irrevocable tax trusts if you have more than the federal estate tax amount. Well, we know in 2026, the federal estate tax is coming back to $5 million plus inflation. We are guessing that it's going to put us somewhere around $7 million apiece, which would be $14 million for a husband and wife. My advice there is to not do irrevocable trust tax planning until you need to, or until you are confident that the law is coming or going to go back. Anything can happen between now and then. And if it doesn't, and it doesn't change, and it is going to come back and you're over that amount, please seek legal advice, right before the law is going to change to ensure that you have the right planning done. But I will tell you, we have a lot of people who have come into our office over the last couple of years who did irrevocable tax trusts when the federal estate tax limit was at $600,000 or $1 million. And I get it, right? They were avoiding a 55% tax. It made complete sense. But now that the federal estate tax limit is up to 12.92 and 12.92 for a married couple for a total of, let's call it 26 million, there's a lot of people who did irrevocable tax trusts who don't need them anymore. And they're not happy that they had to give up control. So an irrevocable tax trust I would not do until you absolutely needed to. To me, what we're calling asset protection trusts from a long-term care situation, the sooner the better. The test that we use a lot of times is if a person has a house or about 150,000 of investable assets that they aren't relying on a daily basis to pay bills. In either of those scenarios, I think it would make sense. So you do get some younger individuals who own a home who want to get that home protected. The sooner the better, because you never know when that 5 years can become an issue. And in these trusts, you can live in it, you can sell it, you can buy another one. So you're still retaining the use and enjoyment rights of it and the ability to sell and to buy, which makes it very palatable for people to want to do them because they're retaining control, but getting the asset protection piece. So in that instance, when you own a home, makes a lot of sense to go ahead and get that put in and get that protected. So for a lot of people, that's in their 30s and 40s. And because we were able to bring the price point down by over 58%, you're seeing a lot of younger individuals putting their houses in trust to get that protected. So that generally is starting to happen at a much younger age than it used to. I think a financial POA should be when a person turns 18. And I think, the healthcare side, because they're free and because you can get them through your doctor, while I generally recommend that you get it done with a lawyer, at least you can have something in place to ensure that decisions can be made for you. Better than nothing, certainly. So I think that might be a little less important, and certainly the will becomes more important as you start to have more assets in your name. But remember, with a will that is still left in your name alone, which means if you end up in a creditor situation, in a long-term care situation, those assets can be taken. So when do estate plan? I think when you turn 18, get your POA in place. As you gain more wealth or assets in your name alone, get that will in place. Definitely get a healthcare power to ensure that other people can make healthcare decisions and you're not relying on a healthcare statute, particularly if you're in another state. That could be extremely confusing, but also daunting and time-consuming. And a trust, I would say, whenever you own a home or about 150,000 of investable assets that you're not relying on a daily basis, that is when I would get what we're calling an asset protection trust. And when you have more than the federal estate tax limit, to get the irrevocable tax trust. So different points in life, different timing in terms of wealth and in terms of where you are. So short answer is, once you turn 18, get the process going, get it started today. As always at Belomo & Associates, we offer free weekly workshops in pre-planning, crisis planning, special needs trust planning, as well as administration after death for both probate and trust administration. Give us a call at 717-845-5390 if you'd like to attend one of our free workshops. We offer them in York and Lancaster on a very regular basis, and also live via Zoom, both out of the York and Lancaster offices. So we'd be able to also have you watch from the comfort of your home a live event that is occurring. I hope you enjoyed the podcast today on when to estate plan. I'd love to see you at one of our upcoming workshops to gain some information about our different topic areas of estate planning. Please feel free to check us out on the web at www.belomoassociates.com or 717-845-5390. If you're looking to get legal advice, please call an attorney in your state licensed to practice law in that state in the practice area that you would like to get advice in. If you're in Pennsylvania and you'd like advice, please give us a call at Belomo & Associates. We'd be more than happy to help you, and we look forward to seeing you soon. Thanks for joining us on the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo. Until next time, we'll see you real soon.